Good morning to all gathered here. And the main idea of this meet is to celebrate all the winners of the KSRI first online ADR essay competition, despite this pandemic being the big spoil sport. So before we are commencing with this formal interview, I'll just speak a few points about the competition and about how the actual assessment or the evaluation of the submission is done. So first about the competition. So we have started with registration of competition in the mid of March. So we received almost 320 plus participants globally. To name few of the major countries where the participants came, like India, we received from India, Sri Lanka, Bangladesh, Dubai, US, and UK, and few other countries. So we received like a tremendous response towards this registration and the participation as well. So on deciding the topic, whether a regulatory body in the field of arbitration, a boon or ban, we analyzed so many pros and cons, whether there is an actual need of a regulatory body and how far it's going to bring in the structure in the field of arbitration, and on the advantages and the disadvantages of a regulatory body in the field of arbitration and other area practice. So once we floated, so upon analyzing all these things, we floated with the topic of our first KFCRI online AC competition, that is a regulatory body in the field of arbitration, a boon or a ban. So after that, so we gave a sufficient time, almost 45 days, for all the participants to give their submissions. So it ended on the last of June, and after that we started with the evaluations. So the second one, speaking about the jury members and the evaluation of the competition. So the basic evaluation is done on 5 criteria. That is understanding, relevance, reference, and this originality. So on speaking about the relevance, we need to know how far you're directly answering to the topic of the question, topic of the competition. That is the question. So on understanding, we need to test the knowledge. So we tested the knowledge on the topic of on the scoring criteria of understanding. So on the part of reference, we need to give the evidentiary value of the appropriate material you have used. And the next was the format. How far you have brought your presentation in a coherent structure. So that was one main criteria. And originality. Originality, apart from your original words you are using, how other than the direct quoting of the references, we have given the originality, that is we have gone through the plagiarism and other thing as an initial scoring. So this is all the main criteria we have given for the evaluation of all your submissions. So you all know very well of jury members. So our jury members are diversified international jury members. Like they had both interesting and difficult task of evaluating all your submissions, because they have to go each and every line of reviewing all your points of your given submissions, and they finally arrived to the score. So based on the top score we arrived, we selected the winners of the competition, that is you all people who are gathered here. So this is all about the competition and about the jury members and how far we have done with the evaluations. So we'll start with our formal interview with winners. So I have an order of interviewing. So the first will be the Charu and Sulagna. A small introduction about Charu and Sulagna is Charu Joshi and Sulagna Chatterjee is basically a law students, and they are from the Rajiv Gandhi School of Intellectual Property Law, that is IIT Kharagpur. So I think that I sit with them to speak about a few words of the competition, the experience as well as the topic. The first winner is among the 5 is the Charu Joshi and Sulagna Chatterjee from Rajiv Gandhi School of Intellectual Property Law, that is IIT Kharagpur. So I'll just start with the very first question. What was your basic experience in participating in our KFCRI first online ADR essay competition? We can start with Sulagna. Sulagna, can you share your experience?
Sure. I shall start. Firstly, thank you to KFCRI for actually hosting this competition during the pandemic. So, conforming to the present circumstances in itself is such a huge initiative from your end. Regarding the competition, firstly, arbitration wasn't taught to us when we actually enrolled for the competition. So, owing to the competition, we learned a lot about arbitration, the ad hoc, the institutional, and even the reason why a regulatory body should or may not be there. So that's how we proceeded with our essay. Both of us had our own opinions. We tried to amalgamate as much as we can, and yeah, it all worked out for the good. Yep. And it was a learning experience because, as I said earlier, we didn't actually have arbitration yet, and we were in the first year of our law school when we wrote the essay.
Okay, that's nice. Nice of you. And Charu, can you please share your experience as a participant in our competition?
Yeah, am I audible?
Yeah, you're audible.
Hello. Yeah, okay. So my experience as a participant, see, first of all, we got introduced to the field of arbitration through this essay competition. We looked up into various matters or uh, matters that revolve around the field of arbitration and the issues that are currently connected with it. We uh, we went through a lot of research papers and yeah, and even I remember during the time when we used to sit in the mess and we used to have discussions around how we're going to go about the essay and how we're going to, like, what all topics do we have are not as much relevant. And yeah, so all in all, it was pretty nice working on the topic and uh, going through different domains of the within the topic itself. Yeah.
Okay. Charudoshi, can you just give your opinion or your contribution towards the topic? Like, what is your opinion on the topic of
Yeah,
our
so
competition?
we went for the notion that there should not be a regulatory body in the field of arbitration because the entire essence of arbitration revolves around giving autonomy to the parties involved. And if we try to regulate that, we're obviously compromising with that particular autonomy. Also, the uh, various international institutes of arbitration in Singapore and UK, they don't have uh, they don't have government regulations on these institutes as such. Like uh, uh, and we yeah. So wait, let me reiterate. So what I want to talk is that the famous arbitration institutes in UK and in Singapore, all of them function rather in an autonomous manner. And even in the BN Sri Krishna committee report, uh, the like it was mentioned to to not have a regulatory like to not regulate these institutions as such, to grant an autonomy and yeah, that's about it.
Okay. Thank you, Charu. And Sulagna, what is your opinion on the topic of a regulatory body?
Yeah, I'm actually with Charu on that. I don't think there should be a regulatory body. Firstly, main reason is that the idea of having a regulatory body would actually be in the setting up of a standard. Now, these standards would vary from country to country because most of our trade right now is international trade. So again, the sovereignty of countries, international law, all that comes into the picture. And a regulatory body, especially in the international field, will be like extremely hard to comprehend and even actually articulated the very essence. Now, most of our study or our essay dealt with the recent Arbitration and Reconciliation Act of 2019, which actually sets up a body. But as we go through the provisions, it was supposed to standardize, but however, it seems to be taking over the entire arbitration, and the autonomy of the parties is lost, as Charu had mentioned. And one of the we read a couple of research papers, and I think a few of them from Yale actually pointed out that how the privity of parties, the autonomy of the parties actually help them check their own arbitrator. If you if you use a regulatory body, there's actually, you're limiting the scope of a couple of arbitrators, and indirectly adding a limitation on the autonomy of the parties. So yeah,
Also, there's no international consensus among the, there's no uniform international system for arbitrational standards as such. So regulating it would also be another problem, because there are some countries which don't even distinguish between an international dispute and a national dispute, international arbitration in dispute and a national arbitration in dispute. So so since there is no uniform standard followed internationally, uh, uh, regulate going for a regulatory body would also further complicate this entire process.
Okay, so thank you guys. As like so it has its own pros and cons. So you guys give your views on of the topic of the competition. So I'll just move on with our next winner of the first online literacy competition of KFCRI. So winner is Mr. Shiv Thakur. Action about Mr. Shiv Thakur. Shiv Thakur has done a submission in this competition for this meet. So the both are from D.Y. Patel College of Law, Navi Mumbai, and basically they are. Mr. Shiv Thakur, my first question will be: what is like what's your initial experience in participating in our competition?
First of all, good morning to all of you. Good morning to the KFCRI family and my fellow participants who won the competition. I'll begin with giving my apology on my behalf of my co-author, because she's not able to attend today's meeting because she's a bit preoccupied with some other work. Talking about the competition in particular, a big congratulations to KFCRI for conducting this competition amid this all chaos of this pandemic thing. But yes, the very thing that captivated us towards the competition was the topic itself. It's an arbitral institute, it's a renowned arbitral institute, and we were already dealing with few other papers in arbitration, so it captivated us and we tried to do our best. Even the same as of Sulagna and Charu, we still do not have arbitration as in our syllabus. We are yet to study that. But we try to cover those principles, at a key stage, so that we do not have to face any trouble on the later stage. And KFCRI's competition has really helped us a lot, because we really worked for this competition in the last 10 days of the submission. For the first 5 days, we did the research, and for the rest 5, we literally wrote everything, and we almost concluded the complete essay around, I guess, 10 or 10:30, and we submitted. I think Shanmuga must be remember. We submitted around 11:58 or 11:55. So it was a very nice experience. It was enthralling one, and it was truly nice. So when we are talking about the topic in particular, about the regulatory authority, so we were not completely against of having in commission body which works for the arbitration proceedings, but we were of rather a mindset that we do not need a regulator, rather we need a kind of a facilitator, which will help, because it is true that there is an arbitration. There are like several amendments has come, and there are various debatable provisions from taking consideration from the 1996 Act to 2015 or 2019. There are various provisions which are very debatable. So yes, there is a need, but the other than being will help in functioning of the arbitration rather than controlling it. And I'll completely agree with Sulagna the way she said that the 2019 Act has really overpowered the autonomy of the arbitration proceedings. It is true, various provisions such as confidentiality or see accreditation. We already have our organizations such as KFCRI or CARB which accredit arbitrators. So there is nothing wrong in regulation in those terms, but yes, few points such as government influence and confidentiality or having various other clauses. So there are various debatable provisions of the 2019 Act, which according to us might create more hindrance towards the development of the arbitration and talking about the institutional arbitration in particular, because of which the ACI has gained so much attention, that it will help institutionalizing arbitration in India and making it an international hub. So yeah, so when we are talking about the provisions of the 2019 and particularly ACI as a regulator, according to us, we think that it will create more problems. It will create more debatable provisions, which again brings out the importance of putting the same thing on the hands of the apex court by deciding various debatable provisions to a judgment, and again brings out the pro arbitration active role played by the judiciary in deciding all these provisions. So, yeah. I'm really sorry, Sanva, but I'm not able to hear.
Thank you, Shiv Singh Thakur. Thank you. Thank you for your view and your participation in our competition.
Yeah.
So, thank you. So we have our next winner of the competition, that is R. Suganya. So a small introduction about R. Suganya. R. Suganya is from Satyabama University and she's a law student as well. Suganya, to start the interview, can you just give a brief thing about your experience as a participant in a competition?
First of all, I would like to thank the KFCRI and the team for conducting the essay competition where we were able to share our experience and learn something. The essay competition was a little bit challenging and was a learning experience too, where I was able to learn something new, that is arbitration, and I was able to develop a deep understanding and critically think and analyze from different perspectives and learn something institutional arbitrations and how it does work, and I felt that it was a very good experience too.
Okay, so moving on to my next question. What is your opinion on the topic need of a regulatory body in the field of arbitration?
I just opposed that we should not have that regulatory body. When I go through the Amendment Act, I found that the ACA, that is Arbitration Council of India, as a regulatory body, is not as has a government supervision and sorry, has government supervision, and is also and is not very flexible. And I felt that.
Suganya, you're muted. I'm sorry to interrupt. Your mic is muted. Can you please unmute it?
Where did I stop?
Yeah.
Okay, sorry guys. First, when I go through the amended act, I figured out some of the elements, say such as what is the objective of the our regulatory body, then who will be the council of members, what are their rules and functions, whether the regulatory body could achieve their a goal by considering all such factors. I then looked upon all the available sources and figured out that the regulatory body allows government and court intervention, because from the amendment we can say that the council of members will be appointed by the government and will be and has a government supervision, where the council of members will try to focus on the needs of the government rather than to improve or promote the institutional arbitration. right? And I also accord and next is the grading of the institutional arbitration. Grading is done based on the general norms, right? And general norms, and also the Supreme Court or the High Court will grade will has given the power under section 11, I suppose, to designate those institutions graded by this regulatory body. Here I felt that these provisions doesn't talk about the clear standard rules or the procedures for the grading, and which will stay as an hindrance for the rising institutions. If say It's because if the regulatory body rejected the if the regulatory body rejects the institution just because it couldn't satisfy their needs, and which will only discourage it, I felt. And ACI as such is not so very flexible, and is very dependent on the government and lacks independence, and lacks independence. So my suggestion was that our Indian judicial system should support arbitration and area practices, because they need more transparency, independency, and justice delivery mechanism. Hello, I'm on mute. Hello.
Suganya, I'm very sorry. Your network bandwidth was very low for the last like 2-3 minutes. I'm very sorry.
Okay.
Can you please repeat to that points alone? Like, can you answer the second question alone again?
Okay, from the first. Okay. First, when I go through the amendment, I figured out some of the three elements. Say, what is the objective of AC as a regulatory body? Who will decide the council of members? What are their functions and roles? And third is whether the objective of a regulatory body is achievable. And after deciding all those elements, I relied upon all the available sources, and I found that the AC as a regulatory body allows government and court intervention. Firstly, it is because we all know that arbitration and area practices as such needs independence and transparency. But if the government keeps on involving right from the appointing the arbitrators, and right from appointing the arbitrators, guiding, monitoring, and framing the rules on their behalf, under the name of regulatory body, will lack independence and transparency, right? And then next is when it comes to grading of the institutions. Grading is done generally based on the general norms, and I felt that there is no, and generally based on the general norms, and our amendment act also gives the Supreme Court or the High Court under section 11 power to designate those graded institutions by the regulatory body. And these provisions lack the standard rules and regulations or the procedure to be followed in grading procedure. If the institutions are not if the institutions couldn't meet the needs of couldn't satisfy the needs of the regulatory body and get rejected, I felt that this will discourage the rising institutions, which is against the objective of ACI and the regulatory body itself. And then when it comes to ACI, all the rules or guidelines is subjected to challengeable, right? And then subjected to challenge. So if so, then the grading process. If so, then the grading process of the ACI and the awards being rendered by the institutions will also be challengeable and will lead to complexity in arbitral proceedings. So I feel that ACI, that is the regulatory body, lacks independence, flexibility, which is very necessary in arbitral proceedings, that too for the party autonomy, right? So I felt that ACI as a regulatory body will stay hindrance for the rising institutional arbitration in India, and will fail to attract the international seat too. And my suggestion is that our judiciary system should support more on arbitration and ADR practices, and should discourage government and court interferences to promote arbitration. And these were my opinions. And finally, I would like to thank KFCRI, their team, jury members, for encouraging students to develop and enrich their knowledge during this pandemic through this essay competition. Thank you.
So thank you, Suganya. Thank you for your wonderful view. Our next winner is Meyyappan. So basically, he's a law student from School of Excellence in Law and the Tamil Nadu Dr. Ambedkar Law University. So Meyyappan, so my first question will be like, how was your experience in participating in our KFCRI first online ADR essay competition?
Yeah, it was a unique experience. Like the topic was a little different. So like you couldn't get any materials as such if you just choose it. Like in many other competitions, the topic might be of any of the important laws. So you might just get the materials directly. Like someone might have already written on it. So it wouldn't be tough. But this topic was arbitration, a regulatory body, whether it is a boon or a bane. So this is not like we don't have much materials on this. So I had to think and write. And in my essay, I had written like for both the sides. What if we had a regulatory body, and what if we didn't have a regulatory body? But the topic was really good. It was very unique, so that we could express our own views. But what I felt was, since arbitration basically is about party autonomy, if we have a regulator, they might like tell some rules and regulations, and if that follows, then basic idea behind arbitration would be lost. So that was what I concluded my essay with.
Okay, that's interesting. So I know that I'll ask my next question. What is your opinion on the topic of a competition?
Yeah, like I said, the topic was very unique. Like you had given a regulatory body, whether it's a boon or a bane in the field of arbitration. Yeah, like now we have the 2019 Amendment Act for the arbitration, and the Indian Council of Arbitration probably is the only one which is there. And we don't have much institutional arbitrations, or at least as far as India is concerned, institutional arbitration institutions are not much. So yeah, this topic was good actually, because we could talk about both the sides. You know, if we have a regulatory body, what happens, and if we don't have a regulator, what happens. But like if you go for an institutional arbitration, what happens is they have their own set of rules and regulations which they follow to conduct arbitral proceedings. So you know, you can like take that as a regulatory mechanism for now, and if we have a regulatory body, then it would be good.
Okay, thank you. That's really interesting, and thank you for your time and effort.
Yeah.
So our
It was
next winner. Yeah, please.
Yeah. So yeah, I would like to say it was a very unique competition, and the topic which you gave was very nice. Do conduct more such events. I'll be happy to participate.
Definitely. Thank you so much. So our next winning team is Sonali, Jain, and Aadesh, Ramadorai. So both are from School of Excellence in Law, basically law students. So Sonali, Jain.
Yeah.
Hi. So how was your experience in participating in our KFCRI online AC competition?
I think it was a wonderful experience. It was very well conducted, from the registration to the submissions. We got timely updates, emails, so that was it was very organized. So that is something that I appreciate. And it's a wonderful topic, and it's great that you guys are taking up initiatives to keep like students and lawyers both like intellectually engaged during the lockdown. So I had a good experience. Thank you.
And what is your opinion on our topic? There is a regulatory body in the field of arbitration is the Pune ban.
So arbitration, even though it's a niche subject, it is still very broad, in the sense there are different kinds of arbitration. And what Aadesh and I did, that we focused our paper on the problems of arbitration. and whether this regulation will be good or bad. We split the word regulation also into two. We spoke about positive regulation and negative regulation, and how regulation doesn't have to be prohibitory in nature. And I personally do believe that some sort of regulation is required, and it doesn't take away from the word, because what positive regulation is, it's not taking away a right that the judiciary has in giving it to arbitrators, but only giving a new right or new responsibilities to just smoothen out the process. Because at the end of the day, even today, enforceability does go to courts anyway. So if you can make that process simpler, or if you can make that process a little more efficient, then that is good. And I do believe that the Supreme Court and in a lot of things like automatic stay for arbitration, or when it comes to the time period, there are lots of ambiguities, and we feel like a regulatory body would be able to clear the gray areas and sort of provide a clarity, which I believe is very necessary, at least in today's world, and in growing arbitration, to make it make India an international hub for both domestic and international arbitration.
It's nice. It clearly shows how much research you have gone through, and really that's interesting. So next is Aadesh. Can you please share your experience as a participant in our competition?
Thank you, sir. So I feel that the topic was really nice. It was a new topic on which, as previously stated, there's not much material. So our approach was really creative, and it really involved a lot of thinking, and it was not really, there was not much material on it. And I was really happy because it helped me expand my knowledge on arbitration.
Okay. Can you please share your opinion on the topic of a competition?
Certainly, sir. So in addition to what Sonali had said, I would like to say that the arbitration system in India with respect to regulation, it wasn't really strong, due to which it kept going back to the judiciary here and there. And now, since regulation mechanism is there, and with the improvements that we have suggested to the mechanism, like, for example, clarifying gray areas, the system can be more independent and less dependent on the judiciary. Another example could be that foreign arbitrators, after the introduction of the 8th schedule, they turn towards the judiciary to appoint arbitrators to them, because the 8th schedule has narrowed down their own choices. So they are left with no other option but to approach the judiciary. But a regulatory mechanism by which accredited arbitrators could be presented as a choice to them would make it more credible and make them more comfortable in choosing these accredited arbitrators rather than depending on the judiciary again. So yes, regulation really helps in improving the system of arbitration.
Nice, and that's interesting. So thank you all the participants. Thank you for your valuable time and effort. And once again, congratulations to all the winners of our KFCRI first online ADR SE competition. So as KFCRI will all come up with another wonderful opportunity very soon. So to know more updates, to know more from us, to get updates from us, do follow us on our social media accounts from LinkedIn or Facebook. Thank you. Thank you all.